All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Welcome to the North Carolina Court of Appeals in our beautiful courtroom. I'm Judge Valerie Zachary. To my right is Judge Allegra Collins, and to my left is Judge Fred Gore. Assisting us today are Deputy Clerk Catherine Bryant and Officer Tom Salou. We have one case for hearing this morning, and then we'll go into ceremonial session for two swearing-in. The first one is in the matter of DJ from Chatham County District Court. Are the parties ready to proceed? If you'll go ahead. Have you reserved time for rebuttal?
Yes, Your Honor. The state will be asking for 8 minutes for rebuttal.
8 minutes?
Yes, Your Honor.
Okay, thank you. Because we're live streaming, if you wouldn't mind giving the audience a little background.
Yes, Your Honor. Good morning, and may it please the court. My name is Ben Zaney. I'm with the North Carolina Department of Justice, and I represent the state in this matter, and I request 8 minutes for rebuttal. There's a well-established presumption that statutes enacted by the General Assembly are constitutional and that the burden of proof is on the challenger to show otherwise. Here, the trial court erred by finding that the mandatory transfer statute was unconstitutional when that burden was not met. As background, in this case, the juvenile was charged by petition for several C, D, and E felonies, including assault with intent to kill, inflicting serious bodily injury, and 7 counts of discharging a firearm into an occupied vehicle. Under the statute, 16 and 17-year-olds who are charged with A through G felonies and who have a grand jury indictment and are noticed of that grand jury indictment, those cases are to be mandatorily transferred from district court to superior court.
That statute's been amended since then, hasn't it?
Yes, Your Honor. It's been amended at least twice since then.
What does it provide now?
The First Amendment provided much the same, maybe just clarified the language, Your Honor. It removed the word finding and just made it so that if a grand jury indictment exists, essentially, and there's notice been provided to the respondent, then transfer goes to superior court. I think it made that more clear, but it still had the same spirit as the statute that's applicable in this case. The one after that changed it so that the jurisdiction for these cases begins in superior court. I believe if it's an A through an E felony, Your Honor.
Was that in 2024?
I believe that was effective December 2024, Your Honor. But this case deals with the statute that was in effect in November of 2023, which, like I said, is 2 iterations prior.
Counsel, what's your assertion of our standard of review in this matter?
The standard of review for constitutional issues, Your Honor, is proof beyond a reasonable doubt for a facial challenge such as this. So under these circumstances here, the juvenile here was in the age range and had committed felonies of sufficient severity. The grand jury returned indictments, and the juvenile was noticed of those indictments. Under those circumstances, the trial court here had no discretion. The statute says shall transfer the jurisdiction to superior court, and so it decided and said that this was an unconstitutional statute and moved towards a discretionary hearing.
Well, was it an automatic transfer, or automatic divestment of juvenile jurisdiction, or was it a transfer subject to the discretionary charging authority of the district attorney?
Your Honor, it was not subject. If anything, it's subject to the decision of the grand jury, Your Honor.
Well, but who convenes the grand jury?
Presumably the state in these cases.
Right.
But that's not the decision that's being at issue here. The issue that defendant has raised and the issue as ruled out by the trial court below was that the trial court believed he had to hold a discretionary transfer hearing. The issue wasn't the indictment, Your Honor. The issue was that under the circumstances, the statute requires transfer.
But only if there's an indictment.
Yes, Your Honor.
Which must be, it would basically get started by the district attorney, right?
Understood. Yes, Your Honor. Agree. However, that's still a decision being made by a grand jury, Your Honor.
Okay.
So, and that's true of all criminal cases, at least all non-juvenile criminal cases for felonies in North Carolina. They all at least any case that is indicted, goes before a grand jury, and that's how the case comes before the Superior Court.
Is there room for disparate treatment under that statute? Can it, with the district attorney's charging authority?
No, well, no, Your Honor, I don't believe so. Just because the disparate treatment I think that you might be referring to, Your Honor, would be a claim of selective prosecution under the Equal Protection Clause, but that's not what the ruling below is based upon here. So prosecutorial discretion cases are reviewed very narrowly for Equal Protection Clause issues, which the Equal Protection Clause has not been raised by the order or by the parties below. And so under these circumstances, that's outside of the scope of what the order touches on, Your Honor.
But by enacting the statute, did the state create a liberty interest that's protected by the Due Process Clause?
Not under the terms of this statute, given that it's a mandatory transfer, Your Honor. Given that the trial court here has no jurisdiction, then the state believes that no such interest has been created.
Well, how do you respond to defendant's argument that since the juvenile was initially subject to the jurisdiction of the juvenile court, he was statutorily vested with all the benefits and rights to that court's special processes?
Your Honor, that has to be understood consistent with the case that the state cited in its Memorandum of Additional Authorities, which discusses limits of the jurisdiction. When a state court's jurisdiction is by statute, as the juvenile court is here, when the court is faced with a statute requiring it to act in a certain way, and it does not act, it's acting outside of its jurisdiction. And so here, the mandatory transfer statute requires that the court act in a certain way to transfer jurisdiction to the Superior Court. The moment that it decided not to do that, it was acting outside of its jurisdiction, Your Honor.
And hence your citation to Turner in your Memorandum of Additional Authority?
I believe it's In re TRP, Your Honor.
Is it In re TRP? That's right.
Yes,
That's
Your
right. DJ cited Turner.
Yes, Your Honor.
Okay.
Yes, Your Honor.
Excuse me.
No, it's okay. So I just want to turn to the trial court's order in this case, which dealt with Garrett, and I believe misinterpreted Garrett. And I think that that's really the core of its...
Well, while you're talking about the trial court acting in a way it was not permitted to by statute by having the motion for a discretionary transfer hearing, I'd like to hear a little bit more about that.
Yes, Your Honor. So once here the trial court found everything that the statute required it to find for transfer. In other words, the trial court found that the juvenile here was 17 years old, had committed sufficiently serious felonies, or was alleged to have committed sufficiently serious felonies, and that the grand jury had indicted and notice had been provided. So under those circumstances, the trial court had no choice under the statute but to transfer jurisdiction to Superior Court. The moment that the trial court declined to do that after making those findings, it's now acting outside of the statutory jurisdiction granted by the legislature.
Was it acting outside of its jurisdiction by hearing a motion, by entertaining that motion for discretionary transfer?
I think that question is less clear, Your Honor, because it's not clear at the point where it heard the motion, at least to me, Your Honor, in the record. It's not clear at the point where it heard that motion if it was aware of, if it had an indictment in its hands, Your Honor. But I think the moment that the court has the indictment in its hands, at that point, then it's clear, and the notice, and I think at that point it's clear.
But the statute doesn't seem to anticipate the court hearing a motion for discretionary transfer in this particular type of case.
I would agree with that, Your Honor.
And so, was it acting outside of the bounds of its jurisdiction in doing so at all?
I think it could. It could be acting outside of its jurisdiction, Your Honor. I think as soon as the statute, the mandatory transfer statute, as soon as those four characteristics were met in this case, then at that point, the mandatory transfer statute deprives the district court of continuing jurisdiction and requires that jurisdiction be transferred to Superior Court.
Did it have jurisdiction to hear a motion for discretionary transfer?
I think it could have, Your Honor. I don't think it did in this case.
In this type of case, did it have jurisdiction to hear a motion for discretionary transfer?
It could prior to receiving an indictment, Your Honor. But once, like I said, once those...
The trial court could properly hear a motion for discretionary transfer?
It could receive and rule on one, denying it, Your Honor, under circumstances such as this.
Even with this level of felony charges? Well, I guess they didn't have the felony charges until they had the indictment.
Yes,
Is that what you're getting at?
That's what I'm getting at.
Okay. And if it did, then it would no longer have subject matter jurisdiction? Is that your contention?
It would no longer have statutory jurisdiction over the juvenile proceedings.
Which grants the court its subject matter jurisdiction? Is that what you're getting at?
Yes, Your Honor.
Okay,
So
thank you.
counsel, if I'm understanding, you're saying that the court could entertain a hearing on it. The question is whether they could properly rule on it prior to having the indictment in hand.
Yes, Your Honor. I guess to be more clear, I guess what I'm saying is the court can entertain motions. It has the power to entertain motions.
Yes.
However, once those mandatory transfer boxes were checked by the facts of this case, the court at that point could no longer hear motions.
Understood. I guess my question is, what's your contention if the indictment's not yet returned? And would it be proper for the court to continue that motion hearing until there is indictment or not? Because what if the court ruled prior to the indictment? What is your contention if the court ruled prior to the indictment?
Well, there wouldn't be a basis for mandatory transfer until the indictment came back, Your Honor.
Even though there are A through G felonies pending?
Right. But at that point, there would just be juvenile petitions for those, Your Honor. So the mandatory transfer here would have just been, in this specific case, it's because the indictment. So it's sort of putting the cart before the horse to say, well, could it have ruled on a mandatory transfer when that mandatory transfer hadn't yet been manifested?
But again, would it have been proper for the court to rule, or would they have to keep the cart behind the horse?
I think they would have to keep the cart behind the horse, Your Honor, and wait for the statute to come into play.
Okay.
Just turning briefly then to Garrett, which is the focal point of the trial court's decision here. The state believes that the trial court misinterpreted Garrett. That's not the only issue that the state raises with the order below, but we're going to focus just on the Garrett piece. Garrett was this court's decision in 2021, and in Garrett, this court analyzed U.S. v. Kent, which is, again, a case that's cited by the trial court here in its order extensively. In Garrett, this court said, Kent explicitly based its holding on due process's interactions with the requirements of the applicable statute. And then they also wrote, Kent requires hearings and findings to support a transfer of a juvenile from juvenile court to adult court when that is the existing statutory scheme. Kent did not create a fundamental constitutional right or constitutionally protected interest to a juvenile hearing or being tried as a juvenile. So this court is bound by that. The trial court below is bound by that. The trial court came to essentially the opposite conclusion as to that part in Garrett. And under the circumstances, the order below is error. I'm going to touch briefly on just two other aspects that have been.
So what process do you contend is due to a juvenile under the current, or not the current, but the past iteration of the transfer statute?
The process that's due to the juvenile is the same process that applied here under the statute. That once the juvenile is, assuming that the juvenile is of a certain age and the felonies are of sufficient severity, the only process is the grand jury indicts. And under that situation, the juvenile receives notice of that indictment, and at that point, jurisdiction is with the Superior Court under the statute.
Do you have a right to appeal this?
Your Honor, yes.
You going to get there?
Yeah, well, I can wait for a if that's okay. We believe that we do. The state notice appeal under 2604, Your Honor, which identifies the state as a proper party for an appeal. It says the appeal may be taken by the state. And it says the state's appeal is limited in delinquency or in a discipline cases to an order finding it. One of the options is an order finding a state statute to be unconstitutional. And that's part B1 of that statute. That's 2604, 7B 2604.
But doesn't 04 just identify the parties who could be proper parties to an appeal? And 02 talks about the right to appeal?
Understand, Your Honor, that's not the state's interpretation of that statute, but understand that that could be an interpretation of statute, and that's why the state filed a conditional petition for writ of cert, Your Honor. And we think that this case would be a good case for cert if this court rules that the state doesn't have a right to appeal. But as it stands right now, this is a situation where there's a district court order that a statute is unconstitutional, and essentially the district court is now proceeding to in the state's view, an extra jurisdictional hearing. And so under those circumstances, what should have been entered by the district court was a final order within that court transferring jurisdiction to the Superior Court. So,
Counsel, I understand the argument, but do we have any cases on point as far as the state being a party to an appeal under the circumstances at which we're facing right now, or is this kind of almost because of the change of raise the age a case of first impression as far as the appellate rights by state?
It is a little bit of a case of first impression, Your Honor. Garrett was under the older statute. Garrett talks a little bit, I believe, about the state's right, or actually, no, I think Garrett was a juvenile's right to appeal, but there is In re PKM, which the state cites in its brief, which was, I believe, a 2010-ish decision by this court under the prior situation. And there it talks about the state being a proper party to appeal a constitutional issue, but it doesn't really get into that because that wasn't the issue before the court. It wasn't a constitution, as I recall, it wasn't a constitutional-based issue there.
What does Garrett deal with the statute that we're dealing with?
Garrett.
Wasn't it prior to raise the age?
Garrett was prior to raise the age, Your Honor.
And so the issue there was really whether it was going to apply retroactively?
That's not my understanding.
Okay,
Your Honor.
okay.
I believe that the appropriate part for Garrett for this court is the discussion of Kent, because the district court here relied heavily on Kent and Garrett's interpretation of Kent, or its belief of what Garrett's interpretation of Kent was. And in the state's view, badly misconstrued what Garrett says and what Kent says. This court is still bound, regardless of the change in statute, this court's interpretation of Kent, and that it's a statutory ruling based on the statute that would be here before the district court, in the Supreme Court's decision there. That's what's relevant out of Garrett, Your Honor, and that's relevant whether it's under the older version, the current version, or the new version. This court is still bound by Garrett to apply its interpretation of Kent consistently, in this case, as it did there.
So does this case really fall within a very small, short time frame of cases that are going to come up? I mean, we've got raise the age, and then we've got the legislature has changed the statute, and it's different now. So how many cases are we talking about that this is going to be similar to?
Your Honor, the record here doesn't reveal how many cases there would be similar to that. And
What's the time frame then?
Your Honor, so yes, so this statute was effective until December 2023. And so if my math is correct, it applied to juveniles who were in a 2-year time frame. And so those juvenile cases could still be charged under that statute for offenses committed while this statute was applicable up until December this year. And then the next iteration of the statute is very similar to this iteration of the statute. It just changed, like I said, it removed the word findings. So the state would contend that the next version of the statute, which is applicable, I believe, until December 2026, would potentially be chargeable. Those offenses would still be chargeable under the 2-year period of age that the juveniles were. I apologize for my math it's hard without a whiteboard and everything else, Your Honor. But essentially, I believe it's about a 2 or 3 year time period potentially going forward that these cases would still be applicable. The number of cases, I can't say, Your Honor, and what concerns the state turning to the petition for cert, Your Honor, is just that the issues with this order and that this order is not narrowly tailored to any specific attributes of this juvenile. It's basically finding just that this is a juvenile who is subject to mandatory transfer, and that's its basis. So it is a broad ruling in that sense, and the state's concern is if that ruling is repeated elsewhere, that it would be problematic, not just because the order, we believe, is not supported by Garrett, but just because the order is so broad and doesn't seem to be narrowly tailored. And this isn't a case where this is something, there's very specific facts here that other district courts could look at and go, well, that's why the district court reached this conclusion. Other district courts looking at this district court, again, they wouldn't be bound by it, but if they look at it as persuasive authority, that's very concerning to the state. And again, these transfer hearings, we go from a situation where the General Assembly has required these transfer hearings be, these mandatory transfers be just a matter of, does the indictment exist? Has notice been provided? And instead, we're going into what now this district court has ordered as a hearing, which is looking at all these different factors that, again, are just outside the scope of the statute here.
So is this a final order, or is this something that can be appealed at a later time when there's a final judgment, if there's a final judgment?
Your Honor, I think it may be difficult to call it a final order in that way. I think that we view our right to appeal as under 2604. However, to the final order piece, like I said, I do think that there is an argument that the court should have entered a final order here. This should be the end of the road for the district court's jurisdiction, and its failure to enter that final order is sort of that issue, is what's that issue here. And so to that extent, we view it as this situation is the final part of its jurisdiction. And so in that light, perhaps it's some kind of final order, Your Honor, but understanding that generally final order might be defined more narrowly than that.
But the court doesn't view it. The trial court does not view this as its final order, right? No, the juvenile court does not.
Your Honor,
the juvenile court is retaining jurisdiction, as I understand it.
Yes, forgive me for interrupting. I apologize. Yes, I believe that that's correct. The juvenile court believes that still has jurisdiction to hear this matter moving forward. And that's what puts the state in procedural limbo here because, again, we don't believe that they have jurisdiction. We believe the case is properly jurisdiction before the Superior Court, but then we can't violate the trial court. We don't want to violate the trial court's order by just going to the Superior Court. And so under those circumstances, we believe we're stuck if the court decides that we don't have a right to appeal to a petition for writ of cert, and that's why I believe that petition for writ of cert is important to grant.
How does that argument, how does the modification of the statute transferring a court of original jurisdiction to Superior Court, the future version of the statute, how does that play as far as being persuasive in this argument?
Well, Your Honor, I think that the next iteration of the statute, not the current one, but the next one, I think makes it extra clear that to be clear, the state believes that the iteration of the statute that applies here is clear. But the next iteration makes it even more clear that it removes the word "a finding by the court," and it just says transfer. Forgive me, Your Honor, I don't have the language in front of me, but as I recall, it removes the word "finding." It just says when there's an indictment and notice, jurisdiction transfers, more or less. And so it makes it extra clear that the district court isn't to engage in any kind of analysis here. It's just looking at, do I have an indictment in my hands? Do I have a notice in my hands? And once I have those things, I no longer have jurisdiction in this case.
But didn't it change more significantly in 2024?
It did, Your Honor. It did, Your Honor.
And with jurisdiction originating in the Superior Court rather than just than the juvenile court?
Yes, Your Honor. Yes, Your Honor.
Go ahead. I was just going to say under 2603D, it says the Superior Court order shall be an interlocutory order. So a Superior Court order transferring jurisdiction is an interlocutory order. Is that correct?
Under the current framework, sending the case from the Superior Court to the juvenile court, Your Honor, yes.
Got it. Okay.
Just the last thing I want to touch on is the Sixth Amendment issue, just briefly. As the state understands the trial court's order, the Sixth Amendment issue seems to be nested with the due process clause claim. So in other words, if there is no right to a hearing, if there's no constitutional right to a hearing, then there was also no constitutional right to be represented at that hearing. And so there isn't a separate Sixth Amendment analysis here that the trial court appears to do. The state believes that those two issues are one and the same, and so because, as here, there is no discretion for the trial court to do anything other than transfer jurisdiction, there is no due process clause violation here, and also then there is no Sixth Amendment violation because there is no hearing for the juvenile to be represented at. So that's our view. We ask that this court vacate the order below and order that the trial court enter an order that the trial court transfer jurisdiction, and I would like to reserve the remainder of my time for rebuttal. Thank you.
Do you have further questions?
Good.
Do you have any further questions?
I apologize.
Thank you.
May it please the court. My name is David Andrews. I represent Daniel the appellee.
Can I start right off with a question?
Please.
What is the significance of the Turner case that you cited in your memorandum of additional authority?
That has to do with this court's authority to issue a writ of certiorari, and it stands for the proposition you all are probably familiar with that interlocutory appeals will normally be dismissed when they are, quote, premature and unnecessary. That's what's happening here. This case could go to a discretionary transfer hearing ordered by Judge Roper, and the judge could still transfer this case to Superior Court. That would render all of these arguments that the state is raising moot. It would be unnecessary. It's just too soon to know if we really need appellate review at this point. To back up a little bit, and I understand you all have questions, and I'm here to answer your questions, but this court should dismiss the state's appeal and deny review, or in the alternative, affirm the order entered below. There are 4 key takeaways that I'd like this court to consider as you're resolving this appeal. First, the state does not have a right to appeal, and its appeal should be dismissed. Second, Daniel and kids in his circumstances have a protected interest that is protected by due process. Third, state legislatures do not define what due process requires, courts do. Fourth, mandatory transfer is not only facially unconstitutional, it's unconstitutional as applied to Daniel. With respect to the first point, As I mentioned, the state does not have a right to appeal. The state is not appealing a final order as required by North Carolina General Statute 7B 2602, and because of that, their appeal is subject to dismissal.
Counsel, on that issue, when would you consider, obviously, you're not doing the work for them, but your argument, for argument's sake, when would it be ripe for appeal? In instance, knowing the procedural posture of how this goes through. There's the transfer, then there's, superior court conduct, and we might be 9, 10, 12 months down the line. When would it be ripe for appeal?
At a minimum, at the end of the discretionary transfer hearing, because the case could still go up. The state can get exactly what it wants.
But would we be at a final judgment at that point?
That still has to do with certiorari review.
And that's my question. So would we be at disposition? Adjudication, disposition?
You could, and look.
Or would it be arguable that it would be post probation or post, serving a sentence?
A dispositional order is a final order. And, the state may not like that route to appeal, but it is the one that the General Assembly created here.
Okay.
The ticket to this court, to get into this courtroom, is a final order, and we just don't have that. Okay.
So question here, it talks about the Superior Court order shall be an interlocutory order that can be appealed only after the juvenile has been convicted in Superior Court. That's 03, right? 03. But would they have the right to appeal at that point? Only the defendant would have the right to appeal after conviction. If they're found not guilty, then they don't have a right to appeal, and then they have never had the right, correct?
I think that's true, and I understand what you're saying. At the end of the day, this is still in an interlocutory posture. That's where we are. And so there is no right to appeal for the state. There's no final order. And so the whole question is, do you grant cert or not? And so I think at the end of the day, that's why I cited Turner. It's still premature. We still don't know if this case is going to go up or not. There is another point on cert review, which is State v. Grunler, which you all know about. Cert review will be denied if an appeal lacks merit. And I do think that this allows us to turn to the merits. We've already heard a lot of argument about it, and it's worthwhile to get there. Under the second point that I mentioned, the second takeaway, there is a protected interest here that is protected by due process. There's a long-standing interest in juvenile court here. We've had it in this state for over 100 years now. And there's an argument that helped frame this question about a protected interest. On page 29 of the transcript of the hearing on this motion, the prosecutor said there's no protected interest here. Only constitutional amendments can create protected interests that get due process protection. That's not true, and that helps put this issue into perspective. Time and again, the U.S. Supreme Court has explained that legislatures, state law, can give rise to a liberty interest that gets due process protection. I'm thinking of cases like Vitek v. Jones, Wolf v. McDonald, Morrissey v. Brewer. Vitek puts it really well. Although a legislature may decide not to confer an interest, if they do, it may not constitutionally authorize the deprivation of that interest without appropriate procedural safeguards.
So is it your contention then that it is significant that jurisdiction originated in juvenile court rather than in superior court?
Wholeheartedly. Absolutely. That is a critical distinction here. That distinguishes this case from Garrett. And
which going back to what Judge Collins said, then makes it just a narrow window here of cases in which that originated, where jurisdiction originated in juvenile court rather than superior court.
That's correct.
So counsel, from a procedural standpoint, and by that window shrinking because of the ripeness of the appeal, isn't this in some regards analogous as far as what happens in adult court when a bill's returned? Because I don't know how much you've been in district court, but you're in district court, there's felony shucks there, and they call the case and the clerk says, Judge, hey Judge, there's a bill of indictment returned in this case. You know what the district court judge does? Can't do anything. And so how do we get out of the standpoint of that this is a decision and there's a bill of indictment sitting showing an intent for it to go upstairs? How does the district court judge then put the cart before the horse.
There is a protected due process interest here. Also, courts under Miller v. Fenton, they have a duty to protect the constitutional rights of litigants. And I want to just tell you practically, so many cases I've been involved in, issues are not preserved because they're not raised at trial. You don't get a ruling on them. Well, guess what? We have both of those here. This trial attorney raised this argument in a court of law. Courts are supposed to protect constitutional rights. And then the attorney got a ruling on that motion, on this constitutional argument. Constitutional rights are not defeated by jurisdictional rules that state legislatures put into place. To get to your question, this is sort of a sideways route to answer your question. There is this point about how do we deal with this jurisdictional issue. This has come up before. We've been down this road, and there are two cases that I think get at this point, Vitek v. Jones and Loudermill, which I think is in my brief, but I also put in a memorandum of additional authority. But that was a case where the state argued that in Vitek, any interest that the inmate had in not being transferred to a mental health facility was satisfied when the doctor made the findings. You can't do anything else. The doctor made the findings. You go straight to the mental health facility. That's somewhat analogous to this situation. The Supreme Court looked at that, and they said, that's not true. We reject that argument. They say that the minimum requirements of procedural due process are a matter of federal law, and they are, quote, not diminished by the fact that the state may have specified its own procedures that it believed were adequate. So don't go looking to mandatory transfer provisions to tell the court what due process requires. They follow up with this in Loudermill. It's an even longer discussion about this point that you're making. It's an employment case. They talk about Vitek, they talk about other cases, and they say property cannot be defined by the procedures provided for its deprivation any more than can life or liberty. They say that the question of what process is due is, quote, not to be found in the relevant statute in that case. The right to due process is conferred not by legislative grace, but by constitutional guarantee.
So what process do you contend is due to this juvenile under the iteration of the statute that we're dealing with?
A discretionary transfer hearing, as we have under 7B 2203.
I guess, counsel, in light of there being a statutory system for discretionary, are you saying there is something prohibiting a juvenile from petitioning the court to hear an objection to the automatic transfer?
There's not a procedure, I'm sorry.
Because if there's a motion filed,
Mhm.
I find it hard pressed that there would be a district court judge that would prevent you from being heard challenging the automatic transfer. So I hear you saying that that right exists, but I don't see a deprivation of it if it's not being challenged. To get me to where, so the transfer, automatic transfer exists, yes. Where is there something preventing a juvenile from being heard to object to that automatic transfer in the procedural process?
I mean, what I'm saying is the judge was right to hear this motion, rule on it, and grant it. I hope that helps.
Yeah,
Okay.
it does. Because the argument without an objection seems that there would be a contention that something is preventing a motion to be heard to object to it.
Yeah, there are, subtle things happening here. Of course you can make a motion and get a ruling on it. The problem here is just that this process is mandatory and automatic, and there's not a meaningful hearing that due process envisions. There is not a meaningful hearing on the question of whether Daniel should be stripped of all of his rights and confidentiality and protections that he gets in juvenile court and is then prosecuted as an adult in superior court. I would be remiss if I didn't talk about Board of Regents v. Roth. We need to think about the nature of Daniel's interest here. Is there a protected interest?
I just want to ask you, does the
Yes, ma'am.
current iteration of the statute cure the constitutional violation you allege exists in the former one?
Could which version of the
The
statute?
current, the one that is the most recent version.
Where jurisdiction originates in Superior Court.
You all have already decided that in Garrett. That That is a Garrett version of Superior Court jurisdiction that originates in Superior Court. I'm not making an argument that that violates due process in this case. You all resolve that in Garrett. I hope that answers your question.
So the answer is yes, the current version does not have suffer from the same constitutional infirmities that the one you're arguing.
Yes, apologize. Roundabout way of yes.
Okay.
Thank you.
Yeah.
Let's talk about the nature of Daniel's interest here. The case that helps us answer that is Board of Regents v. Roth. It's mentioned in the state's brief. And that's where the U.S. Supreme Court talked about how a protected interest is one where there is more than, quote, an abstract or unilateral expectation. Roth was a case with a non-tenured college professor who sued a state university when they declined to rehire him. Did he have a protected interest? No. He couldn't point to anything showing that he had a legitimate expectation of being rehired. In making that decision in Roth, the Supreme Court noted something that is helpful here. It noted that the university did not make any statement that would damage the professor's standing or impose stigma on him. So there's a lot to unpack there, but there's also a lot that we can apply to this case and the interest that Daniel has. First, as I mentioned, there is this long-standing interest in juvenile court. We're not retreating from that interest. If anything, we're expanding that interest. Second, as part of Raise the Age, this case started in juvenile court. I alluded to that earlier, which makes this different from State v. Garrett. This is a critical distinction. And this came up in INRI BTD, cited by the state in its brief, and another case that I included in my Memorandum of Additional Authority, State v. Angelau out of Utah. The gist of BTD and Angelau are, you can't lose what you don't have. Well, guess what Daniel has here? He is in juvenile court. He has something meaningful here.
So it's your contention that he had a constitutionally protected liberty interest?
Yes, yes.
In his status as a juvenile?
Yes, correct.
And all the attendant processes that...
Yes, yes. Which leads us to the discretionary transfer hearing. A third point here about the interest in juvenile court gets at a question that you pointed out earlier, Judge Zachary, about the prosecutor's discretion under the statute. In hindsight, I would have included a version of that statute in the appendix of my brief, and I apologize, I wish I had done that. But I do want to point out two provisions that are relevant here that help us think about the nature of this interest. Again, I'm talking about the 2023 version of 2200.5. Subsection A1 allows prosecutors to override mandatory transfer. They can keep a case in juvenile court, even if it qualifies for mandatory transfer. On top of that, like totally separate from that provision, is subsection D, which is reverse transfer. Prosecutors can claw that case back to juvenile court even after it's gone and been transferred to Superior Court. Those are two additional provisions that are bolstering this interest that already exists by starting in juvenile court. Fourth, we know that these provisions matter because the General Assembly took them away. In criminal law, we refer to something like that as consciousness of guilt. You know, I don't mean guilt per se, but what I do mean is it reflects an awareness by the legislature that there was something important and meaningful going on there. Otherwise, they wouldn't have taken it away, but they did. The last point is about, this point that I made about Roth, where the Supreme Court said there was no protected interest, in part because the university had not made any statement stigmatizing or damaging the professor's standing in that case. Well, if you think about automatic transfer, you got to think about stigma and, less standing. That's exactly what happens when you leave the protective confines of juvenile court where you have confidentiality, and then you go to Superior Court where if you're convicted, you have a permanent felony convictions that follows you around for the rest of your life. Ultimately, though, all of these provisions that apply to Daniel, unlike Roth, they are tangible. They are concrete mechanisms that give rise to a legitimate interest in starting and staying in juvenile court. Daniel's not like that poor, non-tenured professor in Roth. He has a legitimate expectation that gets protection from due process. After you determine if if you're thinking about the analysis for this case, after you determine that there's a protected interest, you apply the Matthews test. There are three parts. You look at the juvenile's interest, the state's interest, and the risk of an erroneous deprivation, and then you determine what process is due. This court has applied this test in In re WBM and In re Roberts. You can do it here. The first factor, of course, is Daniel's interest. He and kids like him, of course, have a huge interest in staying in juvenile court. There's just no question. It's protective, it's rehabilitative, and it's just in no way as punitive as superior court. Juvenile court exists to ensure that the mistakes that you make as a young person don't haunt you the rest of your life. You're treated as the young person you are. The second factor is the state's interest. Now, the state argues that it has an interest in an expedited summary proceeding, but you still have to weigh that against, the serious and significant interest that juveniles have. But then there's this third interest, the risk of an erroneous deprivation. In Morrissey v. Brewer, the U.S. Supreme Court talked about that factor in an interesting and helpful way. They talk about how society has a stake in restoring individuals to useful life. That point is uniquely suited for juvenile court and the question of transfer. The whole point of juvenile court is rehabilitation and getting kids to a place where they can be reformed and live a useful life. When you balance all of these interests, all three of them that I've mentioned, the juvenile's interest in remaining in juvenile court outweighs the state's interest in an expedited procedure. And what that balance results in should be a discretionary transfer hearing. Morrissey also says society has an interest in treating the individual with basic fairness. Basic fairness involves giving Daniel a chance to fight for his interest before it's taken away. This is a uniquely American principle. Give Daniel his day in court. Still another way to think about this statute is to realize that we are not far from satisfying the minimum requirements of due process. We all have this notion of what due process requires: notice and a meaningful opportunity to be heard. The statute does require notice. Check. That's a good thing. It also requires the exercise of discretion. Again, that is a good thing. The problem is just that that discretion is vested in the wrong individual. I included in my memorandum of additional authority another case, In re Spivey, out of the Supreme Court of North Carolina, and it says bluntly, due process requires a neutral decision maker. The authority over transfer shouldn't be exercised by a party or an adversary in the case. It's like having a basketball game where one of the teams decides if the other team committed a foul. This is the one piece we're missing here. We need judges to be able to be judges on this question.
I guess, counsel, on that I guess your analogy of basketball, I like sports analogies, but can it be argued that the grand jury is the referee and the teams are technically even when you have an objective grand jury convened by the people who don't know either side? We do have serious felonies that are identified to be part of this review, and that while the best interest of the juvenile is the Polar Star of North Carolina, but we have potential or alleged victims that also need an objective referee calling the fouls. And so couldn't it be argued that an objective grand jury takes that guesswork out of it for the district court judge, and whenever there's an indictment handed, then the judge has to say the grand jury's spoken?
No, because the grand jury is only looking at whether a crime was committed.
And I understand they indicted ham sandwich. I don't, turn a blind eye to that argument that has been alleged. But that is a system that we have right now. So how can we turn a blind eye to that indictment that then gets presented to the judge, and then the judge still says, I don't care about that indictment?
Because the grand jury is not deciding the question of transfer. They're not deciding the question of amenability.
I I'm saying that is used by the judge to say, okay, there's been something returned that the judge could then use to make a better decision versus just saying it's unconstitutional because I don't have anything else. There's something other than just the judge listening to the state. There is an indictment that they then can use. I'm not saying that is right.
Gotcha.
I'm just asking you, how does that play into the analogy of basketball and one side calling the fouls when someone other than the judge has given them something, I guess?
It's still not any sort of hearing. You know, grand juries are done in secret. There is no opportunity at all for the juvenile to state his or her case to the judge that I should be able to stay here. I can be rehabilitated. That's not a meaningful hearing. That is a paper that is returned by a grand jury. There is no opportunity, for example, for the attorney to act like an attorney, to present evidence, to make arguments, and try to persuade. That is not due process. I was saying it's not meaningful if we go back to the question of discretion. It is the state that is you exercising discretion to seek this indictment, to transfer this case, and it's not a meaningful process if that discretion is being decided by your adversary, your opponent, the one who is trying to prosecute you as an adult in superior court. At the end of the day, we're almost there with this statute. We just need the discretion that is vested in the state to be vested in judges, not unlike you, who are neutral arbiters to decide whether the case should be transferred. That's the process that's due. We also heard a lot about Kent in the state's brief, and I just want to say a couple things about Kent. When you look at Kent and this case, Kent is actually closer to this case than I think the state would like. Like Kent, this case started in juvenile court. You know, juvenile court in both Kent and this case has, quote, original and exclusive jurisdiction over the case. In both Kent and this case, the legislature granted discretion. It's just in Kent, it was the judge that had discretion, and here it's the state. But if in Kent, the Supreme Court required that discretion to be exercised in a way that comported with due process, that same principle should apply here to the discretion that the prosecutor wields against Daniel. I do think it's worth it to touch on the out-of-state cases that the state relies on. They don't apply to this case. First, some of the cases are factually distinguishable because they start in superior court. You know, I've talked about that. This case is not like those out-of-state cases that start in superior court. Other cases, like Aleem and Fussell, are distinguishable because they don't have provisions like A1 and D that I mentioned earlier that give prosecutors discretion to keep the case in juvenile court. That's a key distinction. Third, Aleem and Fussell don't grapple with Vitek and Loudermill. In Fussell, the Supreme Court of Louisiana was blunt. They said, it is the prerogative of the legislature to engage in this balancing calculus. Again, I point you to Loudermill and Vitek. No, it is not the prerogative of the legislature. Courts say what due process is because it is a constitutional guarantee and not a legislative grace. The last point, the last takeaway, in addition to upholding the facial challenge, this court should also affirm the order below based on an as-applied violation. As-applied arguments are separate from facial challenges, but they're still meaningful. The Supreme Court of North Carolina granted an as-applied procedural due process challenge in State v. Thompson. This court recently granted an unpreserved as-applied argument, albeit under the Second Amendment, in State v. Radomski. It can be done. Our courts engage in as-applied analysis, and there are reasons to uphold this order on as-applied grounds. Daniel responds to authority. When prosecutors, court counselors, and judges have asked him to meet certain conditions, he has done so. He's demonstrated an amenability to reform. He's the type of kid that juvenile court is built for. We want kids to be rehabilitated, and he has shown that he can be. He also has a job and a family, And so mandatory transfer would be especially harmful to him because it could mean taking him out of his job, away from his family if he's prosecuted, convicted, and given an active sentence in Superior Court. At the end of the day, asking for judges to decide the question of transfer with a discretionary transfer hearing is not a radical concept. There's already discretion being exercised here under the statute. Due process just requires that that discretion be exercised by a judge. Discretionary transfer hearings are also already a feature of our court system. I'm not asking anyone to reinvent the wheel. The General Assembly has also changed the law. So any ruling by this court, hypothetically, that affirms the order below would only apply to a smaller class of kids subject to this statute. It would not have a wide-ranging effect. Its holding would be limited. Finally, we've had 2 judges now who have been troubled by the mandatory prosecution of children as adults. The first one in Garrett, the second one in this case. This idea that mandatory transfer violates due process is not only correct, it's an idea whose time has come. Daniel really does have a legitimate interest, a meaningful stake here in remaining in juvenile court that he should have just a chance to fight for. I'm not asking that he should absolutely stay, just that he should have a chance to fight, to be able to convince a judge to keep him in juvenile court. For all the reasons we've discussed, this court should dismiss the state's appeal and deny the state's request for the issuance of a writ of certiorari. In the alternative, this court should affirm the order entered below and find that North Carolina General Statute 7B 2200.5 is unconstitutional either on its face or as applied to Daniel. If there are no further questions, thank you.
Thank you. Please proceed.
Thank you, Your Honor. I'm just going to briefly respond to a couple of the points made by my friend on the other side. First is the suggestion that Matthews should apply, and Matthews' line of cases should apply to this case. Matthews itself says that due process imposes constraints on governmental decisions. Here, the statute does not require any decision by the trial court. It is an automatic transfer by the trial court, and there is no analysis being done. And on that basis, all of the cases that are Matthews' analysis cases cited by respondent, all involve clear decision points for whoever the finder is of fact or whoever the determiner is in those cases. For example, in VTEC, the issue was whether a physician could make a decision about a prisoner's mental health treatment, like a compulsory decision about their mental health treatment. That's obviously a nuanced decision. The same is true in Morrissey. It's talking about revocation of parole, which is an inherently discretionary decision by the trial court. Those are all things that are being looked at that have broad discretion for the court or whoever the decision maker is to make a decision. Here, because there is no discretion in this statute, as respondent concedes, as the trial court here concedes, because there's no discretion, there is no decision by the trial court here subject to this type of Matthews analysis. And then even more notably is that none of the cases cited talking about this Matthews analysis, at least from the state's reading, none of them seem to be prosecutorial discretion type decisions. They're all other things, other like ancillary type of issues, but not a prosecutorial decision. Some of them deal with criminal cases like VTEC, or the parole case, Morrissey, but they don't deal with the prosecutorial discretion to charge the case. And that isn't the decision point here in this statute. The decision point here in this statute is what the trial court does once it has a copy of the indictment in front of it, given by the grand jury, not by the state.
Counsel, understanding that argument once you're there, reiterate again your contention of the state's ability to appeal this without a writ.
Yes, Your Honor. So because the court found under 2604, the state can appeal findings that a statute is unconstitutional, and that's what happened here. Our argument is that that statute gives us the right to appeal this scenario. To the extent that the court chooses to look at the other statute, speaking of a final judgment, which I believe is 2602, then our argument is that the court should have entered a final judge. The district court would have entered in what is in effect a final judgment for it to transfer jurisdiction to this case to Superior Court. It did not do that, even though the statute required it to do that, and even though under In Re TRP, the statute or the case cited in the state's memorandum of additional authority essentially deprives the district court of jurisdiction to do anything else other than what the statutes require it to do. So under those circumstances, this was a hard decision point. This was that's passed. At this point, in the state's view, the district court no longer has jurisdiction to do anything in this matter. And that's why this particular matter is important. Even if this court doesn't believe that there's a right for the state to appeal this matter, it's important for it to take up as a petition for writ of cert. And just to touch on that point, because I know Turner and interlocutory appeals have been mentioned, Turner is a civil case. The standard that is applied there, like the first one option of the standard has to do with the application of certification under the state rules for civil procedure. And so what applies there versus what applies here, I don't think it's directly analogous. And so we'd ask the court focus on this case and not on Turner, which is dealing in the world of civil cases. I want to talk briefly, again, the state's position that the Matthews factors do not apply here. But to the extent that they do, if this court decides that the Matthews factors do apply, I want to turn to the second point just briefly to talk about the focal point for the error. Because respondent contends in his brief and again an argument that there's a risk of error here. But the statute makes it clear there is no risk of error. The trial court, if it has a grand jury indictment, two similarly situated juveniles who have grand jury indictments for sufficiently serious offenses, their cases will both be transferred. And if they don't have that grand jury indictment, then there won't be a transfer. There isn't a risk under this clear statute that juveniles would be treated differently if they're similarly situated based on the statute. And then on top of that, we're talking about sending a juvenile to Superior Court, which is a process by which proof beyond a reasonable doubt is the mechanism at play. And so defendant has asked to have his day in court. He will get his day in court. Respondent will get his day in court with the highest burden known to that we apply in our court system.
But that's the day in court for the underlying charge, right? It's not the day in court whether to be transferred, because there are serious consequences for being transferred, right? The maximum and the minimum sentences are different.
Yes, the maximum and minimum sentences are different in juvenile court versus Superior Court. But
So the day in court for the transfer is what we're talking about, not the day in court for the charges, correct?
Understood, Your Honor. Yes, but to the extent that there's a risk of error as part of the Matthews analysis, I do think that it's appropriate to keep in mind that there is still a process with full constitutional rights that is behind the Superior Court mandatory transfer. This isn't in most of these cases that are being compared to by the defendant cites to as comparisons. The decision point is it. It's either the right is terminated or it continues. Here, this case is still proceeding. There may yet be a dismissal of charges that happens in Superior Court. There may yet be a finding of not guilty. And so I think that is worth considering as well, that you have the grand jury doing the analysis for the indictment, and you will have another jury potentially doing the analysis at the end of the road. And then finally, just briefly, we do think that the state's cases cited here, especially Aleem, are persuasive here. They deal with the same issues. In fact, Aleem is an Ohio Supreme Court case. The dissent raises Matthews, and the majority opinion there does not. And it's because Matthews simply doesn't apply. We find that persuasive. We find the analysis in Aleem persuasive. We find that the other state cases cited in the state's brief are also persuasive. We ask that the court consider those. And then finally, just turning briefly to the as-applied challenge here, because, again, we don't contend that our position is that this was a facial challenge ruled on by the trial court. But to the extent that this court is considering any type of as-applied analysis here, this particular respondent, he has not shown constitutional deprivation with respect to the facts in his case, which is how we look at as-applied challenges. It's very fact-specific. And in this particular respondent, works 5 to 7 days a week, supports his girlfriend and his child. He has also had 3 prior juvenile proceedings that the respondent went through in his brief. One it started with a complaint for false report of mass violence on educational property. That went to juvenile diversion. Then there was, or it was amended and then went to juvenile diversion. Then there was a truancy complaint that was resolved through juvenile diversion. And then there was a complaint in 2023, the same year that he had this case come from. for simple assault and false imprisonment, and that was also diverted through a juvenile program. So he's had 3 opportunities through juvenile diversion, and yet we still have the commission of serious offenses here, Class C, D, and E felonies. This is an escalation of offenses, not a de-escalation. This isn't evidence that this respondent is particularly amenable to anything in juvenile proceedings. And so,
Does this order address an as-applied challenge, or does it simply address a facial challenge?
in our view, it's a facial challenge.
So could we even get to an as-applied challenge if the order doesn't get there?
To be honest with you, Your Honor, I don't know for sure. It seems like sometimes courts will get to an as-applied challenge, and sometimes they won't, even though it appears to be a facial challenge to the state to begin with, Your Honor. So it seems like that distinction is sometimes shaky, as the courts have recognized in some of the cases where that line is exactly is difficult for courts to deal with. So I'm addressing that argument in an abundance of caution, Your Honor. Unless there are any further questions from the court, we respectfully request the court vacate the order below. Thank you.
Thank you very much. That concludes oral argument in this matter. I want to thank you, counsel, for your excellent arguments, and we will take this matter under advisement. We need to briefly adjourn and then go into ceremonial session, please. Okay?
All rise. The Court of Appeals is now adjourned.
We're just going to go ahead and stay here and let y'all clear out, and then we'll go ahead and go into ceremonial session for the swearing in. Thank you, gentlemen.